Welcome to EUPrivacyForAll Session38 on GDPR, Article 42, Certification. Article 39 on certification was finally renumbered Article 42. It sets forth that Member States, the supervisory authorities, the European Data Protection Board, and the Commission shall encourage, in particular at Union level, the establishment of data protection certification mechanisms and seals and marks for the purpose of demonstrating compliance with the GDPR. The specific needs of micro, small and medium-sized enterprises shall be taken into account. Moreover, certification mechanisms, seals and marks could be used by controllers or processors that are not subject to the regulation in order to demonstrate the existence of appropriate safeguards provided by those controllers or processors. In such a case, they shall make binding and enforceable commitments demonstrating compliance with the certification requirements. The certification shall, in any case, be voluntary and available via a process that is transparent. Finally, a certification pursuant to this article does not reduce, and this is key, the responsibility of the controller or the processor for compliance. The certification granted according to this article shall be issued by the certification bodies or by the competent supervisory authorities on the basis of a set of criteria approved by the competent supervisory authority or by the European Data Protection Board. Where the criteria are approved by the board, this may result in a common certification called the European Data Protection Seal. The controller or processor concerned shall provide with all information and access to its processing activities which are necessary to conduct the certification procedure. The certification shall be issued to a controller or processor for a maximum period of 3 years and may be renewed. And certification shall be withdrawn whenever it is necessary because controllers and processors do not meet requirements set regarding this accreditation anymore. The European Data Protection Board shall collect all certification mechanisms and data protection seals and marks in a register and make them publicly available by any appropriate means. Various recitals from the GDPR enhance key points. For instance, Recital 100 enhancing transparency and compliance and stressing that the establishment of certification mechanisms and data protection seals and marks should be encouraged, allowing data subjects to quickly assess the level of data protection guaranteed by a controller or a processor. Recital 77 on the guidance for the implementation of appropriate measures and on the demonstration of compliance by the controller or processor, especially regarding the identification of the risk related to the processing. Certification could be provided in particular regarding the demonstration of compliance. Recital 81 stresses the fact that the adherence of a processor to an approved code of conduct or an approved certification mechanism may be used also as an element to demonstrate compliance. Different provisions in the GDPR make clear that certification mechanisms could be used by controllers and processors in order to demonstrate compliance. Regarding supervisory authorities' part to be played, Article 57.1 makes clear that they should encourage the establishment of data protection certification mechanisms and data protection seals and marks, carry out a periodic review of certifications, and conduct the accreditation of bodies. They should also review on certifications and withdraw certification or to order the certification body to withdraw a certification regarding some specific cases not meeting anymore the certification requirements. Each supervisory authority shall have also the following authorization and advisory powers, that is to say, accredit certification bodies and issue certifications and approve criteria of certification. The European Data Protection Board will also have at the European level the same mission, having to encourage the establishment of data protection certification mechanisms and data protection seals and marks, carrying out the accreditation of certification bodies, specifying the requirements regarding such a certification, and providing the Commission with an opinion on the certification requirements. Regarding administrative fine, Article 83 also laid down that attention should be paid to the adherence to Code of Conduct and to approved certification mechanisms. The Directive 95/46 had no reference to approved certification mechanisms, seals or marks. What should accountable data controllers and processors get prepared for? Controllers and processors can use certification mechanisms, seals and marks for the purpose of demonstrating compliance with the GDPR. They will have to bear in mind particularly that EU Commission, EDPB member states and supervisory authorities will specifically check needs of micro, small and medium-sized enterprises. For controllers or processors that are not subject to the regulation, the certification mechanisms are still available and they can be used in order to demonstrate that appropriate privacy safeguards are implemented. Certification remains in any case voluntary and transparent. It does not reduce the responsibility of the controller or the processor for compliance, and controllers and processors shall pay attention to the criteria elaborated by the EDPB at an EU level, knowing that a common certification named European Data Protection Seal will be issued, and also by each national supervisory authority. The certification granted will be of a maximum of 3 years, and it is renewable. Finally, controllers and processors will have to commit to provide all information and access to its processing activities in order to make it possible to conduct the certification procedure, and EDPB will hold a public register on certification mechanisms, seals and marks. So the question triggered now relates to the criteria to be used by the European Data Protection Board and by national authorities.